just by way of a very short introduction, because I know nothing about winning litigation, but I think this is a perfect segue from last month's topic, Max's topic, because Max, if you recall, and I'll just read one sentence out of his paper. This is to Adam Brait Max's general thesis, I think, and it was under the heading A Cautionary Note, and he wrote, "The incentives and rewards at law firms and at the bar are often aligned to the default position of being tough, in inverted commas. This leads to a culture of hyper-adversarialism that takes place in an environment where clients are uninterested in moral dialogue and lawyers are motivated to please." So that was the cautionary tale that was attached to Max's paper. This week we're throwing all caution out the window. We're reverting to our atavistic instincts, and it's all about what we can do to get a result. So over to Lachlan.
One of the great legal minds of our time is Charlie Sheen, and this is what he said: "High treason has occurred. The scales of justice are in a state of radical disarray. Together we must right this infantile wrong." But perhaps more importantly, he also said, "I'm so tired of pretending my life isn't perfect and bitching and just winning every second." So, a slightly more classy quote probably is the one that I started off with Lord Eldon in the first paragraph of the paper about the traditional divide between the bench and the bar and who is to do what. It's for the court to decide and for the barrister to argue, but my view about a lot of recent developments is that it's for experts to decide and it's for barristers to sit by and watch, and that trend should be reversed. We should do whatever we can to reverse that trend. It's making the whole system much more inquisitorial and getting further away from the basic premise of what the common law system should be about. As far as I know, there's been no constitutional challenge to things like hot tubs, but I stand to be corrected about that. I deliberately didn't read Max's paper until I wrote mine so that I wouldn't be unduly influenced by it, but it's interesting that both of the papers have a reference to the same paper from Jim Spiegelman about 5 or 6 years ago, where he described what the adversarial system is about. And in my paper, I've referred to the 3 different ways of looking at things in that respect that Spiegelman came up with. The first one, which I think is a bit extreme, is that the adversarial system is not concerned with truth. I think it is, at least to an extent. The second one is that the adversarial system is the most effective way to come to the truth with Socratic dialogue. That's the traditional view of the bar, and I think it's the best view of advocacy. It's the third alternative which seems to underpin most of the reforms that have happened, and this is the one which is perhaps troubling in some ways, which is that the adversarial system is tainted effectively with the pursuit of other values, such as the value of winning, perhaps. But what this means potentially is that the role of expert witnesses and people like that have been elevated where they're considered to be more important than the role of the advocate. So I certainly agree that there shouldn't be a default setting of aggression. That's not good advocacy at all, and it's not going to help anybody win anything. But I think that winning has been somewhat on the back burner because of the emphasis on case management and things of that kind. But we should keep in mind the rules, of course, and the current rules came into force after most of us started practicing at the bar. So I've included the key rules in paragraph 3, and they're pretty basic, but they probably should be at least considered before we get into winning itself. So obviously, a barrister must not be dishonest or discreditable. barrister has an overriding duty to the court and must not knowingly or recklessly deceive or mislead the court. But whilst we have to act within those parameters, I would say that there's an ethical requirement to strive to win. Otherwise, you're just wasting your client's money, I think, provided you do so within those ethical boundaries and don't go over the top and just be aggressive all the time for no reason other than to bully your opponent, which I think long term has negative consequences. But the future of the bar, I think, will be protected if we if we don't compete with solicitors, but rather we emphasise our traditional role, which is that of a specialist advocate. Not necessarily a specialist lawyer, but a specialist in putting together a case. Now, I would be curious to do a bit of a survey as to who is enthusiastically in favour of concurrent expert evidence in this room. Anyone? No hands? No. Well, about 94% of judges and tribunal members are, apparently, according to the research that I did. I've never met a barrister who's enthusiastically in favour of concurrent evidence. So the difference in the priorities of courts and tribunals compared to barristers, I think, is shown in this case of Temple, where the AAT said, this was a fairly early example of concurrent medical evidence, there is a benefit in a more investigative and less adversarial approach. But who benefits? Judges certainly benefit because the decision-making process is made easier. Whether your client benefits from losing control of the litigation is another matter. And it would be a very strange notion of justice to measure justice by how easy it is for the court to deliver the decision. So, to get onto some more practical matters, I think that we need to have more involvement in our experts' preparation of their evidence. It's only in a very small percentage of cases where I'm asked to confer with an expert. I was conferring with one about half an hour ago, and he is the subject of one of the war stories I'll come to at the end, and so I won't refer to him by name. But getting involved early, I think, means it's more likely that the expert evidence will at least be relevant to the case theory that you want to run, although there's an ethical question as to at what point that becomes coaching. I certainly accept that. Now, Justice Garling prepared a fairly well-known paper where he identifies a few problems that he sees with the hot tubbing process, at least potential problems. One is in relation to credit attacks. So credit issues with experts is fairly unusual, but it does come up. What he suggests is that you do the hot tub first on the substantive issues and then send the non-offending witness out of the witness box and then attack the remaining witness on credit. My view would be that it should be the other way around, so that by the time the judge is evaluating the opinion on the substantive issues, whether the witness should be believed or not, it's already been dealt with. And you can see the problems with conventional cross-examination on credit in hot tubs, because the idea usually is that you ask one witness a question, then the other one chimes in with his or her perspective. If you say to someone, you're a liar, aren't you, then it doesn't really work if the other one jumps in at that point.
The other experts are here, damn right.
Yes, I agree.
The other issue is in terms of closing the gates and classical methods of cross-examination like that. It's very hard to do where whenever you get involved with one witness, the other witness comes in and takes everything off track. The other two practical issues that Justice Garling referred to are getting all the witnesses there at the same time, but he refers to Skype technology and things like that, so I don't think that's a big concern. But the other concern is lack of uniformity in the approach of judges, and that is a concern because the practice notes in the Supreme Court have had this approach for a long time, but the district court's only had it for a couple of years. And I think when you have concurrent evidence in that court, there's a lack of experience on the part of some judges in what to do. I'm not criticising them, but it's a new process that's in that jurisdiction come out of nowhere. So I'm now going to talk about some of the technicalities of expert evidence in terms of the different practice notes and that are in the different courts. But I'm not going to go into any detail about admissibility of expert evidence. It's not really the purpose of the presentation. But I think the approach to expert evidence is getting more important because it's close to an expectation now, at least in certain areas. And that's, I think, a pretty recent development. In one of my main practice areas of public liability, often had slip and fall cases a few years ago without expert reports. Now, I probably wouldn't be game to run one without it. So, in the Supreme Court, there's a couple of relevant practice notes. Practice note 11. It says that the questions for the conclave should be those specified by the court or those agreed by the parties. So the order that sentence is drafted is interesting because the starting point is that the court should pose the questions, which again is part of the shift away from the power of the bar. But one big difference between the District Court and the Supreme Court that is not well understood, I think, is that in the Supreme Court practice note, there is a requirement to pose questions. In the District Court practice note, there isn't. The only requirement is that they do, in fact, confer. So you don't actually need to write to the conclave in the District Court. But this brings me to my next practical issue, which is that in both Supreme and District Courts, there's been an emerging problem where one party solicitor writes off a letter to the conclave without telling anyone what's happening, with highly leading so-called facts or assumptions which totally skew the whole process in favour of that solicitor's client. So in my opinion, that's a bit of a dodgy tactic, especially in the District Court where there's no requirement to do that at all, either by agreement or otherwise. But I've seen a lot of cases where there's a lot of toing and froing and a lot of money wasted with solicitors arguing about what should happen at a conclave. I think the simple solution is just to, if this happens, write to the conclave yourself or get your solicitor to, and just say, put your pens down until we sort it out, and then go to court and get some sort of relief. And a lot of the relevant practice notes, especially in the Supreme Court, tell you which list judge you have to go to sort those things out, and if there's no practice note on point, you can do it under the rules. There's also the Federal Court Central Practice Note, CPN 1, which says that the party's approach should have in mind the most effective, efficient and economical way to manage evidence. I might ask rhetorically, why? That's the court's problem. But one interesting thing in the Federal Court Practice Note is the reference to consulting experts, which I don't think is referred to in any other practice note, and it's an interesting approach to expert evidence. So your primary expert obviously has to adhere to the code of conduct and not be an advocate and that kind of thing. But you can get another expert who is a gun for hire, whose report's never going to be served, that's just used for private purposes to prepare your cross-examination of the expert who actually gives evidence. Federal Court Practice Note's also got some other interesting ideas, like appointing a conference facilitator, and also some interesting points about timing of conclaves. So they can be ordered in the middle of a mediation, for example, if there's a deadlock on a factual issue which is holding up settlement. There's also a difference between the federal court and the state courts about whether lawyers can get involved and when. So the federal court practice note says lawyers can attend the conclave with an order, but the UCPR is vague as to what's required. It says that the court may make a direction that lawyers either do or don't attend. It doesn't actually prohibit it or allow it as such. It just says the court can make a direction. It seems to be a pretty rare thing for lawyers to attend the Conclave, but I don't see any difference between attending it and writing a letter to them in particular, in terms of having some input. The commercial and technology practice note has its own requirements as well, and with a strong preference for joint evidence, but I would suspect that in that list, expert evidence is likely to be less central than in other areas in terms of quantifying losses with accountants and things, rather than working out whether someone is liable as such. When you're conferring with an expert, I think there's a danger with expert ego, and quite often they can try to pressure you into having things in the report that they think are very important, which really aren't as far as the case is concerned. And quite often they will suggest things to you that ultimately backfire. There's been another practice I think that needs to stop, where lawyers write to experts really asking for a judgment rather than for an expert opinion, to the point of even referring to cases and legislation. I was very flattered when I saw one of these letters that referred to an unreported case that I'd been involved with, but it really didn't need to be brought to the expert's attention. The other thing is, experts think that they know more about the law than you do sometimes, and always. And one thing you see, for example, in work injury damages cases, where everyone always pleads the occupational health and safety law, but no one ever refers to it after the pleading, that they're always very keen to put in huge slabs of that legislation. This is stuff from economics experts, people like that, who think they're an expert on whether the OH&S law applies or not. It's just a bit bizarre. The same experts tend to attach hundreds of pages of Australian standards and photocopies of textbooks and all of that, and the actual reasoning might be a paragraph, and the reasoning will just be a reflection of what the qualifying letter was, and so there's really no joining of the dots and no real persuasive value anyway. When you're conferring with an expert, in most cases they will know the other expert involved in the case. They've often worked together or whatever, but this can backfire as well. So there was one orthopedic expert I had, and I was asking him about the other orthopedic expert. And he said, look, this guy's not even a member of the Royal College of Surgeons. I mean, he doesn't know what he's talking about. So that was the first question I asked him. I said, would you expect an orthopedic surgeon to be a member of the College of Surgeons? And he said, generally yes, but, and then I cut him off. And then the tribunal member intervened and let him finish. And the explanation was that he was so senior that the college didn't exist when he qualified. Yeah. Probably still joined. Yeah. So, in terms of what courts expect now about expert evidence, in paragraph 26 of the paper, I've referred to the Coles Supermarkets case, which is a case that I lost about a week ago. So, in that matter, the Court of Appeal was very critical of the expert evidence because it didn't, this is a slip and fall case again, because it didn't actually say, well, there should have been a system every so many hours or minutes, and because there wasn't that system, there should be a verdict for the plaintiff. So the court there, the appeal, wasn't persuaded by what I said about, well, there's evidence about number of people at the site and the nature of contamination of the floor surface and things like that. They really, I think, wanted an expert to set it out. So it's because of cases like this that I think that you've really got to have your expert evidence 100% right now, whereas perhaps a couple of years ago it wasn't as important. Now, another interesting difference, I think anyway, between district and the Supreme Court in terms of expert evidence is, in the district and the local court, cross-examining party has to get the other side's witness there, and in the Supreme Court you've got to get your own witness there. So this leads to a lot of confusion where a court's ordered a joint report, but in the district court only one expert's been required for cross-examination. People feel like they have to bring their own expert along in order to have a hot tub. I don't think you do. I think you can just have conventional cross-examination if that happens. But that's another area that's, I think, misunderstood a lot. So I'll just go through some of the case examples about expert evidence and where advocacy might have made a difference or not. Yep.
Sorry, just on that last point, isn't the rule that if they do have a conclave, that they have to give concurrent evidence?
I think to the extent that they give evidence, it's concurrent, but if there's only one, then there's only one. That'd be my understanding. So the first case example I've got in Part D is Tabit, which may no longer be applicable because it was decided before AI risk. But it just says that where experts bring up a new issue for the first time in the conclave, then you can amend your pleadings. That seems pretty logical. Hopefully that's still correct after Aon. One potential trap, I think, to be seen in the Andonovsky case, where there was an orthopedic conclave, but there was also a doctor, Dr. Ellis, who was a general surgeon, but providing orthopedic treatment. He didn't turn up to the conclave, no one told him to, and the plaintiff just managed to get his evidence in, but from the judgment it looked pretty borderline as to whether it would happen. So I think where there's any ambiguity about how close the experts need to be in their expertise, the best thing to do whenever there's any doubt is just get a direction about it from the court, and there can be no criticism later. The next case is Campton, and the big takeaway message from that, if I read it correctly, is that you can't make a Makita and Sprouse objection to a conclave report because it's not a requirement for experts to expose reasoning as to why they agree or disagree. Only a requirement to expose the reasoning for their opinion as such. I've included the Matthews and SPI case here because it just shows some interesting practical ways that you can approach complicated concurrent evidence. This is a Victorian case where Justice Forrest decided to appoint an Associate Justice to manage the conclave, and he, I think it's a he.
He's doing a bushfire case.
Bushfire case, yep.
Justice Forrest.
Yeah. And he specifically ordered that the parties could have lawyers, but no more than 3 per party. So now just an example of experts running amok is in the Qantas case, which was a competition case. One of the experts described the other side's evidence as almost entirely bogus, and that it was a desperate attempt to bolster a case which had failed comprehensively. I think even if your own witness is saying things like that, you probably need to get the court or tribunal to intervene, even though that might be a bit embarrassing, because otherwise things are just going to get even worse. But I think, I don't know what preceded these comments by the witnesses, but at some point it seems like they took control of the case. So I'll just close that paper now and talk about a couple of other examples I've personally come into contact with. So there was a special list in the district court involving Dr. Ackerman, where there'd been a huge number of reports which were extremely similar except for the name of the plaintiff, many of which said that children had very similar symptoms like bedwetting and that kind of thing. And there was a suggestion by one of the insurers that this was a bit of a scam, and the district court created a special list to call over all the matters with Dr. Ackerman's reports in them to entertain applications for personal cost orders against him. So That's another area for advocacy. If you're particularly acting for a plaintiff, if you start a case on the basis that you think there's reasonable damages involved because of an expert report you've got, and that report turns out not to be correct, you might have some recourse against the expert, personally. Another theme, one that I've personally encountered, is the expert for all seasons. So, excuse me. I was doing a bullying case for a defendant, and the plaintiff tried to call a particular expert about bullying, and then in a voir dire I cross-examined him about whether he was actually an expert or not, and the judge found that he was an expert in ergonomics and not bullying. Similar.
Depends on
And,
you're not getting a bit too confused.
and so his report was knocked out. And then the following week I was appearing for a plaintiff in an ergonomics case, and I called him, and his report was knocked out because he was a bullying expert. I don't know what the answer to this is, but there's a real issue with lack of control over what comes out of a conclave. So I had a case where an old lady was walking up to a counter in a fish and chip shop and tripped on a grate which was out of alignment. And our expert had said that anything below 5 millimetres in misalignment is safe, but this is about 7 millimetres, so there's negligence. Then, as the years went by before the conclave happened, he'd obviously forgotten what he said, and then he said, "Oh, it's definitely under 5 millimetres." And this just came out in a conclave report a few days before a hearing where enormous amounts of legal fees had been incurred, and prospects of success obviously changed very rapidly shortly before the hearing.
Was he insured?
So I would be interested in everyone else's experience with conclaves and hot tubbing and how to win where we've got less control than we once did.